Is president of the American Society of International Law. He's now with Baker McKenzie here in New York, former assistant legal advisor for treaty affairs. He taught at Cornell Law School, so he's got he's not only a practitioner, but a government official and an academic, combines it all together. And we've known each other for about 35 years, I think, since we both worked in government together. In any event, I'm not going to take any longer, just to say what a pleasure it is to have him here. And the title of his talk, as you know, is International and U.S. Courts. He brings 3 different perspectives to bear on it. And let's hear what he has to say, which is much more interesting and important than anything I have to say at this time.
Thank you very much, Al. And ladies and gentlemen, I'm delighted to be here. And thank you for the gracious invitation. About 25 years ago, I guess I already knew Rovine. I had become the assistant legal advisor for treaty affairs in the State Department. It was as much executive agreements as it was treaties, but that's another story. After some short time, the Justice Department began a very large project of putting into computers as they then were, so that we could access them as we then could, statutes and implementing regulations in the United States, and they called it the law of the land. And so, of course, it was. But I noticed no reference to treaties and agreements. And that was a bit upsetting, given the supremacy clause, which says the treaties are the supreme law of the land, after all. And so I called the Justice Department and I said, what's happening? What's going on here? Do you intend to treaties? No, they didn't. Why not? They intended to do statutes, basically. I said, well, will you do treaties? We send you all the materials and cover the costs. Well, yes, with some reluctance, they would do treaties if we sent over the materials. I said, what will it cost? He said, well, let me get back to you on that. And 2 days later, he calls back and said, $300,000. And this was back in the mid-70s, and that was a bit steep for the legal advisor's budget, so I thanked him, and that was the end of that. And I found it to be a very depressing phone call, a very depressing story altogether. This was, after all, the Department of Justice. And I said to myself, how can I get this done? I don't want to give up any possible opportunity. And it occurred to me that there might be another department of the government that would be interested in international agreements. And of course there was. It was the Department of Defense. And so I called them and I said, would you like to do this? You do have, after all, military agreements online already. There may be more here. Would we like to do it? We'd love to do it. And how much will it cost? Cost? No cost, just send over the books. And that was it. There was a remarkable difference. Part of it reflected who had the money and who didn't in Washington at that time, and perhaps at every time. And perhaps it was just enthusiasm from somebody who wanted to make sure that all agreements were in for whatever personal reasons he had and not necessarily institutional reasons. Nevertheless, there was a message being transmitted. I thought that the conversations with the Justice Department spoke volumes. They were saying that we think differently about international agreements. We think differently about them because we view them as somewhat softer law. We're not exactly as comfortable with them. And that certainly seems to reflect the view of courts in the United States, thinking much like the Justice Department thinks. They don't feel quite comfortable with issues of international law. They view it as softer law. They are much likely to pay deference to the views of the executive branch than they would in any other kind of domestic law subject. They say, and as a matter of fact, it was just said to me the other day by one of the Circuit Court of Appeals judges, that often they don't get international law issues right, or they don't address them at all, because the lawyers before them don't know much about it either, and don't plead international law issues either at all, or correctly. And you say we're not in the business of making up issues as we decide cases, so that if it's not put to us, it doesn't come out. And then you guys think that we don't know anything about the subject. Maybe we do, but we decide the cases that come to us on the basis of what's put before us. Having said that, there's a general admission around this table, which constituted several judges from the circuit courts around the country, that in fact they knew very little about international law. In fact, the Congress, notwithstanding our problems with the Congress in international law matters, is likely to do more these days than the courts. This is a message that I give you that I think is perhaps a little depressing from my point of view. It might be a very happy one from the point of view of at least some people sitting in the audience. I'm not sure, but we will get into it. I think the problem, the real problem, the core issue here, and why it's becoming more noticeable now than it has in the past, is the problem of treaties dealing with domestic law, particularly when the domestic law is new domestic law. Human rights treaties, for example. Is that a problem? Well, if I look at the explosion of scholarly writings on this, yes. It's largely been defined as a conservative approach, and the liberal approach is defined just the other way. The problem being that as the years have gone by, what used to be called in this country the law of nations has become an international law that deals more and more with domestic law issues. That is to say, issues of law between the government and the peoples that are governed, rather than pure foreign affairs matters. There are always domestic and foreign affairs implications from any treaty, and there were treaties many, many years back that covered individual rights and obligations. But for the most part, they did not. So we've had an increase in breadth and in depth of what international law means today, to the point where, as in human rights covenants and in other human rights treaties, we get the position of, by treaty, making law and doing it without the House of Representatives. And that, I submit to you, is the core issue. When we look at all the scholarly writings, Bradley, Goldsmith, Professor Yu, Harold Coe, Vasquez, all this becomes, in my judgment, the core issue. So let's talk a little bit about treaties, and then I want to go over to customary international law and speak of that as well. The Supremacy Clause, as you well know, does say, all treaties made which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or the laws of any state to the contrary notwithstanding. That's the Supremacy Clause. And it puts treaties on a par with federal statutes. And it raises the implication clearly that a treaty should be enforceable within the federal courts to the same extent as a federal statute. But U.S. jurisprudence has not created a blanket rule whereby treaties, all of them, are automatically given effect. The first thing you note, and it's important in some recent famous cases, is whether a treaty creates a private right of action. The general rule in the United States is that treaties do not create rights that are privately enforceable in the federal courts. And there are cases up until very recently, United States against Lee, which is a First Circuit case just this year. It quotes an interesting statement from the head money cases back in 1884, and I'll read that to see how the Supreme Court thought about it in those days. They said a treaty is primarily a compact between independent nations. It depends for the enforcement of its provisions on the interest and the honor of the governments which are parties to it. If these fail, its infraction becomes the subject of international negotiations and reclamation, so far as the injured parties choose to seek redress. It is obvious that with all this, the judicial courts have nothing to do and can give no redress. That was 1884. I don't think we think quite that way anymore, but it's still a tough battle. U.S. courts will enforce treaties in a particular case if the treaty law is raised by a party only if that treaty creates a private right of action. Is that true of every statute you've ever seen? No. But it seems to be true of treaties. It's different. And the courts are demanding more of it. They treat treaties in a different way. That's what I'm saying. First, of course, to decide whether it's a private cause of action, you look at the terms of the treaty itself. And if the terms are ambiguous, and they may well be, you look to various non-textual sources, and you try to reach a decision. In the Lee case, which I mentioned, First Circuit, defendants were convicted for smuggling Chinese immigrants into the United States. And the defendants appealed on a ground that is certainly famous now, Article 36 of the Vienna Convention on Consular Relations. There was also an article, a very similar article, in a treaty between the U.S. and the People's Republic of China. It was a bilateral treaty on consular relations. And the First Circuit looks at the text, and it looks at the drafting history, and it looks at the application of the treaties, and it concludes that neither of these treaties included or created a private right of action. And so, of course, the convictions were upheld. Perhaps a more famous case than this, just 2 years old, is Braillard, the famous Braillard case. In that one, as I'm sure you all know, Braillard, who was a Paraguayan national, was arrested and convicted after a jury trial on murder charges by the state of Virginia, and he was sentenced to death. In August of '96, he filed a federal writ for habeas corpus, arguing for the first time that his rights under the Vienna Convention on Consular Affairs were violated because Virginia authorities had failed to inform him that he had a right to consult with his nation's consulate. Braillard asserted that if he had been made aware of that option, he would have exercised it, and consultations with the Paraguayan consulate would have convinced him to plead guilty because the consulate would have known, as he did not know, that by pleading guilty he would have avoided the death penalty. In September of '96, the Republic of Paraguay and their ambassador to the United States and their consul general brought a separate suit in the U.S. District Court against Virginia officials, alleging that their rights under the Vienna Convention were similarly violated. And in April of '98, 2.5 years ago now, Paraguay instituted proceedings before the ICJ against the United States. And the ICJ issues what looks like a preliminary order directing or requesting the United States to take all possible measures to avoid the execution of Braillard while the ICJ considered the merits of Paraguay's application. So both Braillard and Paraguay sought permission to bring original jurisdictional claims before the Supreme Court in order to, quote, enforce the ICJ directive. Well, the Supreme Court ruled Braillard's case for violation of the Vienna Convention was procedurally flawed by his failure to raise the claim in Virginia state court proceedings. And regarding Paraguay's claim, the Supreme Court held that it was not cognizable because, and I quote, neither the text nor the history of the Vienna Convention clearly provides a foreign nation a private right of action in the United States courts to set aside a criminal conviction and sentence for violation of consular notification provisions. Well, it seems pretty clear that the courts, when looking at treaties, are going to be pretty tough on enforcement, both by governments and by individuals, unless they can find something in that treaty, that agreement, which provides for a private right of action. Something in the treaty itself, something in the negotiating history, a clear indication, however, that a private right of action was intended. Is this a shying away from a treaty as the supreme law of the land? It does look that way. This case has involved domestic law, domestic criminal law procedure, but it does seem to me they didn't have to come out that way, as they don't have to come out that way with respect to statutes where a private cause of action may not be listed, nevertheless permitted. In other words, treaties and statutes are being treated differently, and the question is why? If one is the supreme law of the land and the other is the law of the land, what is the difference? As I said at the outset, I think it's at least as much psychology as anything else, a feeling that this is different law. It's the same feeling that motivated the Justice Department in not putting treaties online as they were putting statutes online. And the way people think about these matters, of course, will affect the way they behave, which in this case involves the way they will write their judgments when cases come before them. That brings us to the famous issue overlapping with private cause of action of self-executing or non-self-executing. When is a treaty really a rule of decision for the courts in the United States? It's a separate question, it's a related question, self-executing means that no further implementation is necessary, as you know. No further legislation or administrative action or executive order is necessary. If it is, we say the treaty is not self-executing. Well, courts are bound in this country to give effect to international law, to international agreements, says the restatement, and you're absolutely right. But the restatement also recognizes that despite the supremacy clause, we have a tradition of what are called non-self-executing treaties. And they find three categories. Other scholars have found other categories. The restatement says that if the text of a treaty manifests an intention that it shall not become effective as domestic law, meaning as well rule of decision in the courts, without the enactment of implementing legislation, it's not non-self-executing. Or if the Senate, in giving its consent to the treaty, or Congress by resolution, requires implementing legislation, it's not self-executing. Or if implementing legislation is constitutionally required. That's a rare case that it would be said to be constitutionally required. I suppose I can think of some. The raising of money, for example, requires the participation of the House of Representatives, and you can't raise money simply by entering into a treaty. Now, of course, you might say the U.S. is acting at cross purposes if it enters into a treaty on the one hand and refuses to implement it if it's not self-executing on the other. And I think the general view here is that the U.S. is obligated to adjust its laws to give effect to the agreement, and to do so within a reasonable time. It cannot be enforced, but that is the legal obligation. This issue, as to whether treaties should be presumed to be self-executing or not, has given rise, as you know, to this enormous explosion of scholarly literature, which has tended to come down on a conservative/liberal divide. Professor Yu in the Columbia Law Review argues that there should be a presumption that treaties are not self-executing. He supports it with an argument which is derived largely from historical analysis of the debates surrounding the treaty clause, the framing convention and the ratification conventions. He looks at British political and constitutional history to support the argument. As you know, in Great Britain, no treaty is the law of the land without the enactment of a law by Parliament. Canada has similar problems. In Canada, a treaty is not the law of the land for any province of Canada unless that province enacts implementing legislation to make it the domestic law of that province. That's the way they do it. That's the way they've always done it. Professor Yu contends that presumption of non-self-execution is also supported by the concept of separation of powers. Vasquez disagrees in a long and, I think, outstanding analysis in reply. At one point, however, in reaching the conclusion, it's almost an obvious conclusion. He writes, sounding like somebody who wants to climb Mount Everest. Should someone ask me, he says, why I think the Constitution gives treaties the force of domestic law, I would respond, because it's there in the Constitution. That's what the Constitution says. But he too recognizes that certain treaties are not self-executing. He finds even more categories than the restatement does. This brings us really getting down to the issue here that has raised this front and center to the human rights treaties that were sent over to the Senate some 20 years ago, even more. Got to know Al Rubin. The treaties were sent over, as you know, with a lot of reservations, a lot of understandings and declarations. And the effect, or the intent, of those reservations and understandings was to make it clear that we were not entering into these treaties in a way which would change United States law at all. If United States law needed changing in any of the areas subsumed under the covenants, for example, it would be done in the normal course by legislation by the Congress or by the states. There was also a statement sent over by the executive branch that these covenants are non-self-executing. Well, let's take a look just at that one. Can you do this? I think the answer to that one is you can. Foster against Nielsen, Supreme Court says that a treaty can certainly in its text say that legislation is required to fulfill its terms, and if it does say that in the text, that is a non-self-executing treaty. You have to go get legislation. Can you do that by way of a reservation? Did the United States do something that made sense legally? Or was it antithetical to the very purpose, the object and purpose of the human rights covenants, as was alleged at the time? I think legally, it was okay. That is to say, as you all know, the reservation to a treaty constitutes a change to that treaty in some way. It's an addition to the treaty, or it's a subtraction from the treaty, or it's an interpretation of a clause. And in a multilateral treaty, it may be accepted by some parties and rejected by other parties. And to the extent it's accepted, you have that kind of relationship with that country. A multilateral treaty is, after all, a large set of bilateral relationships. If it is accepted, your reservation, fine. If it's rejected, then you don't, to the extent of that particular clause, have that relationship with that other country. Can you say to the Congress, to the President, to the world, this is a non-self-executing treaty? I think the answer is clearly yes. If you could put it in the text of the treaty, which you certainly can, you can say it outside the text of the treaty and make what would have been a self-executing clause into a non-self-executing clause, which is exactly what Foster against Nielsen held. But this has become a very large issue. A very large issue. And why? Why did the administration do it that way some 20 years ago and raise this issue? It was as much political as it was legal. For reasons that are obvious, the House of Representatives does not like treaties. They have been very respectful of treaties, of course, over the years, but they would rather have an executive agreement over which they have some control than a treaty over which they have none. it's difficult for them. For the White House 20 years ago, and in the interest of full disclosure, I have to say that I was still heading the Treaties office at that time, so I wasn't involved in this. It was absolutely essential that we send them over with these reservations, meaning status quo for the time being, and non-self-executing. Because if we didn't send it over that way, two things would happen. One, we would have the House scream as it had not before. Why? Because this is domestic law, and some of it is new domestic law, and they don't want to be cut out despite the treaty clause when it's domestic law. Foreign affairs matters, that's a different issue. But if it's domestic law, which the Founding Fathers were not really thinking of when they wrote the Supremacy Clause, that's an issue which brings the House to their feet. Second of all, the Senate itself might not have been satisfied. It's hard to get 2/3 of the Senate to agree on anything, and you need to get the 2/3. The executive branch is quite capable of saying, well, if we've got the 2/3 on this particular agreement, we'll make it a treaty. But if we don't have 2/3, we think we have a majority, we'll make it an executive agreement. You know, it's what vote requires what form. It sounds not very nice, but it does work out that way has worked out that way on several occasions. Is it worth becoming a party to these treaties under those kinds of conditions, where you know from the outset that these clauses will not be rules of decision for the U.S. courts and will require something more if the law is to be changed, and if that law is domestic law, as it primarily is in these cases? I think the answer is clearly yes, it's worth becoming a party. Why do I say that? First, there is the international commitment. At the very least, you have made an international commitment to follow, as a matter of international law, your human rights situation in the United States as it then was. It means that the treaties themselves won't affect a change. That will have to be done in other ways, but at least there's an international commitment to that extent. Second, it means procedurally, you show up in Geneva, you subject yourself to questions in Geneva at the Human Rights Commission, you subject yourself to criticism in Geneva at the Human Rights Commission. That's worth something. So when the question was put to me, is it really worth doing it under these circumstances, the answer is absolutely yes. Also, of course, when I say liberal-conservative divide, these things have a way of turning around on you very, very quickly. It's another illustration of be careful of what you want, because you just might get it. What's an example? How could this turn around? Well, there's a treaty called the Rights of the Child. Article 6 provides that the child is to get legal protection both before birth and after birth. I heard Ed Williamson, just the former legal advisor of the State Department, just 2 nights ago, saying that that can easily be read as a ban on abortion in the United States. Would you care to do that by just the treaty, just the president, assuming a conservative president who names a couple of more conservative judges to the Supreme Court, Roe against Wade is undone, so it's not an unconstitutional treaty, which would, of course, be non-self-executing. But a constitutional treaty which bans abortion, entered into by a conservative president and a conservative Senate, would most of the people in this room care for that? No, I think probably not. And what happens when you don't care for the substance? After a time, you begin not to care for the process. You begin not to care for the procedure. And that is why we're having a liberal-conservative divide right now, but believe me, it does turn around on you. I shall never forget in 1976, when there was a huge effort to limit the president's international agreement-making power. The idea was to say all executive agreements from now on shall be subject to a legislative veto. They'll send over to the Senate, they'll sit on the table for 30 or 60 days, and if they're not vetoed, fine. And then managed in the full force and effect. But if they are, that's the end of it. Well, the reaction to this was enormous because the liberal-conservative split just completely turned around. To my dying days, I will not forget Senator Fulbright, who said out loud, you know, I opposed the Bricker amendments in the 50s, and boy, was I wrong. He said I should have supported Bricker. He was right. And I'm going to support this legislation right now. There were several people who were around in the Bricker days who just did a complete flip-flop. Why? Because now they were in a mood to limit the president's power to make international agreements, not treaties specifically, executive agreements, and that's a big difference, of course. But that was the mood. It was just after Vietnam. It was just after Watergate, and that was the mood. So these things do have a way of turning around, and what has to be sought here is a neutral principle of law that makes sense. Well, there are other examples that one could give. A treaty limiting internet content. Europe talks more about that than we do here. We have free speech doctrines that are apparently stronger here than there. Is it possible that someday we'll have a draft treaty banning some kind of content on the internet? May well be. What about procedure then that says just the President and just the Senate is enough? Would we like it? Probably not. In any event, that's the issue. It is the core issue. When you go to the Bradley and the Goldsmith and the Yu and the Vasquez and the Harold Coe writings, you come down at core to what do you do if you're a judge with a treaty that creates domestic law, and it is new domestic law. Do we still say that's a self-executing treaty, or do we say, that requires a little more? My personal view is, given the supremacy clause and given our history, it is enough to say that the 2/3 vote in the Senate is sufficient. That has always been the intent. That is still the intent, and that's the way the rule should read. What I am saying to you is, though, this is a big issue. And you will see, as Ed Williamson said the other night, referring to we conservatives, he really was putting himself right in there and saying we conservatives are going to push this. And they are pushing it in the Congress, both houses, pushing it in the pages of the Harvard Law Review, the Columbia Law Review, and elsewhere. It is a major league issue. It is not one of which a great many people are yet aware, but it's there. Be clear that it is there. And I wanted to bring that to your attention and to have you think about it. What do you do with what I'm describing as the core issue of treaty, but it deals primarily with domestic law, and it is new domestic law. Self-executing or not? That's the core question. Then you move over to customary international law. And again, you have a pattern here. First comes the question, is customary law part of federal law? I think we have a feeling these days that it is. I certainly think so, and I think the courts, for the most part, think so. There's no supremacy clause which refers to customary international law, refers to treaties. But what about customary international law? Where does it fit? It took a lot of years, really, before the courts, as a matter of fact, it took really until the 1960s, before the courts were clearly turned around that customary international law is part of federal common law. There had been a notion that this was kind of, to use a phrase, Erie-esque. Erie against Tompkins plays a big role in all of this. And as late as 1948, Judge Learned Hand, writing for the Second Circuit, could say, this was a case having to do with immunity from jurisdiction of a diplomat. He was in transit to the United States. And he says, since the defendant was served while the cause was in the state court, the law of New York determines its validity, and although the courts of that state look to international law as a source of New York law, their interpretation of international law, by which he meant customary international law, is controlling upon us, and we are to follow them so far as they have declared themselves. Now that's really Erie against Tompkins language, if ever there was, and that's 1948 in the Second Circuit. He then went on to say, because I think he saw difficulties with what he had just written, the very next sentence says, whether an avowed refusal to accept the well-established doctrine of international law or a plain misapprehension of it would present a federal question we need not consider, for neither is present here. So I think he saw what might come from what he had just said, and it sounds like Erie against Tompkins, but a little bit qualified at the end. The one who I think really saved the day on this issue and made it absolutely clear what the correct position is from my point of view, and I think from the court's point of view generally, was Phil Jessup. He expressed the view, talking about the doctrine of Erie Railroad against Tompkins applied to international law, a journal article he wrote in 1939, which I guess Learned Hand didn't read in his 48 case. But he said that it would be unsound, as it would be unwise, to make our state courts our ultimate authority for pronouncing the rules of international law. Absolutely right. And then came Sabatino, 1964. This was a case, as you know, that dealt with the active state doctrine. And if there was any doubt up until that time, I don't think there was a whole lot. Although, Bradley and Goldsmith, again, you could say there was an awful lot of doubt, and there still is. But what the Supreme Court said in Sabatino was, we are constrained to make it clear that an issue concerned with a basic choice regarding the competence and function of the judiciary and the national executive in ordering our relationships with other members of the international community must be treated exclusively as an aspect of federal law. It seems fair to assume that the Supreme Court did not have rules like the active state doctrine in mind when it decided Erie against Tompkins. Right. And they then cite Professor Jessup, who by 1964 was sitting on the International Court of Justice. So the view is, at least from the early 60s, and probably a lot earlier than that, customary international law in the United States is federal law. It is federal common law. The restatement refers to it curiously as a kind of federal law. I'm not quite sure why that super cautious language was used. Yes, it's a kind of federal law, and the kind it is, it's federal common law. That's what it is, and I think that's what it has been certainly made clear in the Sabatino case. It's also clear, I think now, because we have enough cases saying so, that matters that arise under customary international law also arise under the laws of the United States. Aki Habana, international law is part of our law. That federal common law for purposes of both the judicial power of the United States includes customary international law, we're talking about Article 3, and the jurisdiction of the federal courts, 28 U.S.C. 1331, is established as including customary international law. Well, what do the courts do with that? What do they do when cases of customary international law come up? Are they, as I think they are with treaties, kind of shying away? I think the answer to that is clearly yes. What would be an illustration of that? An interesting one was decided in the D.C. Circuit in 1988. It's called Committee of United States Citizens Living in Nicaragua against Reagan. Interesting case decided by Judge Mikva. In that case, Nicaragua had initiated a proceeding against the United States before the ICJ, challenging the U.S. military support of the Contras. And the U.S. challenged the jurisdiction of the ICJ, and that challenge was dismissed, and the U.S. withdrew from the merits phase of the proceedings. The ICJ, however, did render a judgment that the U.S. military support of the Contras violated both customary international law and a treaty between the U.S. and Nicaragua. They concluded, and I quote, "The United States is under a duty immediately to cease and to refrain from all such acts as may constitute breaches of the foregoing legal obligations." There was actually a resolution in the Security Council to enforce that. Of course, the U.S. used its veto power to block that. Thereafter, the plaintiffs, the Committee of U.S. Citizens, including Nicaragua, and there were really various groups representing American citizens, started a federal lawsuit claiming that their own rights were violated. There was a dismissal on a political question. On appeal, plaintiffs argued, and here's where it gets interesting, that U.S. military support for the Contras violated three separate aspects of international law. First, there was a treaty in force, namely Article 94 of the UN Charter. Second, there was customary international law to the effect that first, treaties are to be observed, and second, parties must adhere to ICJ decisions, and third, jus cogens, to the extent that plaintiffs contended that the requirement to follow an ICJ judgment was not just customary international law, but jus cogens. Okay. What the court did there, and it was very interesting, for what they said, which was helpful, and what they did, which was perhaps not so helpful. They assumed first that customary international law was a part of the law of the United States, was a rule of decision for U.S. courts, and was applicable to the case before it. Good. However, for purposes of the supremacy clause, the court, this is now D.C. Circuit, the court follows the rule that customary international laws are a part of the federal statute, and thus a subsequently enacted statute will supersede previously existing customary international law. I think that's right. They were right to point to it, and I don't know whether the lawyers put it to them and were wise in so doing, or whether they figured this out themselves, but they got that one right, I think. Congress had, in fact, passed a subsequent statute authorizing military support for the Nicaraguan Contras. And so that was inconsistent to the extent that pre-existing customary international law required obedience to treaties and ICJ judgments. And MICFA wrote that statutes inconsistent with principles of customary international law may well lead to international law violations, but within the domestic legal realm, that inconsistent statute simply modifies or supersedes customary international law to the extent of the consistency. Okay, and the court relies on the Paqui Habana in 1900, where here you have the Spanish owner of a fishing vessel who was captured, condemned as prize during the Spanish-American War. He seeks compensation based on the customary international law rule prohibiting these kinds of takings. Supreme Court holds for the plaintiff, saying, where there is no treaty and no controlling executive or legislative act or judicial decision, resort must be had to the customs and usages of nations. There was a superseding statute in the Reagan case, applicable to the claims, and so MICFA finds inapplicable the pre-existing customary law. The Paqui Habana wording is itself interesting. Where there is no treaty, it assumes a superior status for treaty over customary law. No controlling executive or legislative act or judicial decision assumes that they're superior over customary law. Then resort must be had to the customs and usages of nations. That was the Supreme Court talking 100 years ago. So if you think the courts are weak on treaties, they're really weak on customary international law, and maybe they should be. It's harder. It's much harder. When did it become customary international law? Exactly who are the parties to it? What are the precise measures of this law? It's a tough proposition. But then you go on to jus cogens. And here it got more interesting yet. Because now the plaintiffs are arguing in the alternative that even if customary international law must yield to a subsequent enacted inconsistent statute, which it did in this case, Jus cogens occupies a higher level in the international law order and should have supremacy over federal law. Try to get it. Just try to get that one out of the federal courts. You won't. The plaintiffs claim that jus cogens are absolutely binding upon our government as a matter of domestic law, and such a norm, and I quote, rises to the level of a constitutional obligation which cannot be overridden by a statute. Well, what do you do with that one? Your name is Nippa, and you're in the DC Circuit Court, and you're squirming, and you're feeling unhappy, and you think that this law is somehow different from the ordinary domestic law that you're accustomed to working with, statutes and implementing regulations and executive orders. It's not just soft law as treaty law might be, but this is really squishy, and you're having a tough time. And yet, there's something to what the plaintiff is saying, and you know it. What do you do with that? He's uncomfortable. Well, here's what he did. He says first that submitting to ICJ judgments, this asserted rule of jus cogens, you've got to submit to ICJ judgments, it doesn't meet the Vienna Convention's standards or any other authority's definitions of what constitutes jus cogens. Well, okay. What they did in that case was to draw a distinction between special agreement jurisdiction, in which both nations agree to appear before the ICJ to resolve a particular dispute, and cases of unilateral application, which this one was, in which one nation is held into court on the basis of a prior consent to scope a dispute. And that's his distinction. And he says that compliance with the judgment rendered in the former case may be a norm of international law approaching or maybe even achieving the level of jus cogens. But compliance with the judgment rendered in the latter case, a disputed unilateral application, that's not jus cogens. Well, they said some nice things, however. The Reagan Court states in dicta the basic norms of international law, such as the prescription against murder and slavery, may well have a domestic legal effect that appellant suggests, meaning that even a subsequent inconsistent statute would not supersede such a rule. And so that's how Judge Nippa handled it. He said some things that were appropriate, meaning what I feel in the right direction, but when you got down to the heart and soul of decision, he went the other way. There are other cases, of course, that do like things. The Ninth Circuit, in a case called Siren and Blake against the Republic of Argentina, this is a 1992 case, refused to allow jus cogens prohibition against torture, official torture, to override the Foreign Sovereign Immunities Act, the statute of the United States. They treated it and ordinary customary international law as exactly the same for purposes of the supremacy clause. They found jurisdiction against Argentina. It was on a theory of implied waiver, not because of a violation of jus cogens, but because Argentina had utilized U.S. courts in connection with the issue. Another case called Smith against Libya, 1996, back in the Second Circuit. They rejected the argument that a violation of jus cogens should constitute grounds for meeting the implied waiver of the Foreign Sovereign Immunities Act. Well, as you can see, the court's reactions tend to be similar, and here too, we have this blazing argument going on in the journals about whether it is part of our law, whether customary international law really isn't state law after all, getting back to Erie against Tompkins, which I think makes absolutely no sense. But again, we will come to the core issue. If that customary international law involves domestic applications, domestic law, and particularly if it's new, can we implement it as such right there, rule of decision? Or does the court say, I can't do this, I just can't, I've got to look at some expression elsewhere, such as legislation, executive implementation of some kind of executive order, whatever. Well, I need not go into all the details of those arguments, but they're well worth reading in recent issues of the Harvard Law Review and the Columbia Law Review, both customary international law and treaties, and where they fit into the U.S. System. Now, I've got 10 after 2. I don't know how much time I've got left at this point. A smidgen of time, a smidgen. All right. Well, just very quickly, there are, of course, other sources of international law to which one could repair and ask the question, what do we as judges do with this? For example, decisions of the International Court of Justice. What do we do with that? There's an interesting case recently. It was just last year. The Federal Republic of Germany against the United States. War on the ground. A German national who was to be executed by the state of Arizona for a crime he had committed 14 years earlier. Germany initiated a proceeding before the ICJ. Same issue now. It's going to be a big one as well. His conviction violates the Vienna Convention on Consular Affairs. His consulate should have been notified, was not. He's a German national, and so on. The ICJ here issues a temporary injunction under which it indicates that the U.S. should take all measures at its disposal to ensure that War on the Ground is not executed pending the final decision in these ICJ proceedings. The Supreme Court refuses Germany's application for a stay, consistent with the ICJ indication of, let's call them interim measures of protection, stating simply that, and I quote, given the tardiness of the pleas and the jurisdictional barriers they implicate, we on that one, Justice Breyer wrote a dissent. He says, in light of the fact that both the International Court of Justice and the sovereign nation have asked that we stay this case, or indicated that we should do so, I would grant the preliminary stay that Germany requests. But it was a dissenting view. Security Council resolutions, what about them? Again, you get the same kind of view we've got to implement here. In numerous instances, executive orders are issued that implement Security Council resolutions. But in the courts, they're going to be looking for that. There's a whole other body of law on this that doesn't so much get us into this core issue, which I've raised with you, as it does federalism questions, state agreements with foreign sovereigns. There are a pack of them. We don't think of states as entering into international agreements. They do it all right, and they do it all the time, like every day of the week. Why? I'm not quite sure why. It's fun to travel around and draw an agreement and sign your name to it. States are always entering into international agreements. Are there any limits to this? There's supposed to be limits. You're supposed to get the consent of Congress, for one thing. Do they get the consent of Congress? Sometimes yes, sometimes no. It seems to me they get it if they feel like it. It's odd, but that's the way it is. Any judicial learning on this one? There was a case in 1840, Holmes against Jennison. The governor of Vermont entered into an agreement with Canada regarding the extradition of a particular gentleman named Holmes, who was alleged to committed murder in Canada. And Justice Tony said, and I quote, framers of the Constitution anxiously desire to cut off all connection and communication between the state and a foreign power, and we shall fail to execute that evident intention unless we apply it as to prohibit every agreement, written or verbal, formal or informal, positive or implied, by the mutual understanding of the parties. States can't do it, is what he's saying. Well, the states can do it. They've been doing it for a long time. I headed the Treaties office. I had a variety of these things coming in, exchanges of scientists, exchanges of physicians, building bridges, building roads, all kinds of things that states want to enter into. Someday we'll have cases, I think, having to do with violations by states of their obligations with a foreign power. But the general rule is you cannot impinge on the foreign affairs power of the government, whatever that means. And that is a tough issue. There's something looking to reverse, but really isn't. State sanctions. This is the famous Burma case, Crosby against National Foreign Trade Council. State sanctions against a foreign government, in this case Burma, have to be in accord with federal policy. You can't interfere with federal interests, and a lot of judgment calls will be made there. That is a question of course, speaking with one voice, which is related to the earlier part of what I said in the sense of customary international law not being state law at all. What I want to leave you with is just this. The core issue, in my judgment, is, as I said, international agreements, domestic law, new domestic law. How does the court handle it? How does the government handle it? It is not easy. It's not just a legal issue, as I suggested, it's a political issue as well. How is it easiest to get this thing through the Senate? Is it by saying, all right, Senate, you don't want to give us 2/3 for doing it without implementing legislation? Will you give us 2/3 if we say it's not self-executing and does require? And if the answer comes back yes, and it's easier to get the Human Rights Treaty through the Senate than it otherwise would have been, of course you do it that way. You're more likely to get the Human Rights Treaty you want. Is it worth doing at the end of the day? Of course it's worth doing, because we're making the international commitment and subjecting ourselves to those kinds of international procedures. You'll see a lot, you'll hear a lot, you'll read a lot about that core issue. Think about it, think how you would come out. It's an interesting one, as interesting as we get in terms of international law in the U.S. courts, and I think that's it. Now, thank you very, very much.
To run us right up to the edge of time, so there's no time for questions. So I'll leave this with a couple of comments. First, the speech in its entirety will be published in the biennial proceedings of this organization. So anybody who wants to know will see it, and it's really out of date. And I'm sure that would please up. Another thing I want to mention, I guess, is I know Jack Goldsmith, Kurt Bradley, and John Yu. I don't disagree with them nearly as much as you do, and we're just going to have to leave that to be a matter of other people making up their own minds. I think we're just about time for the next panel, since we better adjourn right now. Thanks very much.